So really, really warm welcome again. My name is Marika. I work at UnLtd in our volunteering and pro bono team. And one of the things we do here is we organize both these webinars with our experts and business mentors, but we also provide mentoring and other pro bono support to UnLtd award winners as part of their support package. I'm really pleased to introduce our host today. Jean Boyle is a senior associate at Stone King Solicitors. Jean works in Bath, but Stone King have branches across the south of England and have been working with UnLtd for probably about a couple of years now in providing some pro bono support and have done a webinar before as well. So really, really pleased to have you, Jean, here. Jean will be introducing herself in a bit more detail in a minute, but we'll be focusing. The webinar today is all about employment law and all about sort of aimed at the early stage social entrepreneurs, at those first steps of you starting to engage other people in your social enterprise. So whether that's engaging volunteers, whether it's the first time you're looking at bringing someone in on a freelance basis, or whether it's actually employing your first member of staff, and really understanding the legalities and processes that surround that, and making sure you get everything right from the beginning. So that's the webinar. We'll be going for, we've got until 1 o'clock. Jean will speak for about 35 to 40 minutes, and then we have time for questions. So please type in your questions through the chat box that you can see at the bottom of the dashboard, and then I will read out your questions to Jean at the end, and hopefully she can answer those. I think that's all. Any problems, if you can't hear us, any issues, type them in, and we'll try and address those. But otherwise, big thanks again to Jean, and I'll hand over to you for the webinar.
Thank you, Marika. Thank you. Hello, everybody. As Marika said, my name is Jean Boyle. I'm a senior associate at Stone King. A bit of background in relation to me. I started out my working life in relation to the legal world as an employment lawyer, then decided I wanted to do a bit of pensions law, so went off to a very commercial corporate firm to do some pensions law for a couple of years, and then came back to the nice safe world of employment law, and I've been at Stone King now for about 7-8 years. Stone King, if you're not familiar with us, have acted for those in the not-for-profit sector for many years. Although I do some commercial work, the vast majority of my work is for organisations, charities predominantly, some schools, especially in the not-for-profit sector. What we're going to talk about, what I should say is that my email address and contact details are on the slides. If anybody wants to email me separately in relation to any questions which they forget or later think of, please feel free to do so. As I say, my contact details are on there. What we're going to talk about, well, we're going to talk, as Mary said, about the very first stages of becoming an employer. It is probably your first experience that you will rely very heavily on volunteers, and that's absolutely essential for the first stages probably of your organisation. Certainly my experience of charities in particular, but also businesses as well. However, as things progress and develop, you might choose to engage self-employed consultants or freelancers, and after a period of time you may take the view that you want to think about employing some staff. In the context of this webinar, we're going to look at the requirements for engaging employees and the accompanying risks, obviously. But what we're initially going to look at are the risks associated with engaging those individuals who come before employees, so the volunteers and the self-employed. Many people think that there's very little risk associated with engaging volunteers. However, organisations do have certain legal obligations towards volunteers and engaging volunteers to do what is often very essential work, and that carries a certain amount of risk. Unfortunately for us, there's no single statutory definition of volunteer, rather oddly, the Police Act, strangely, gives us that definition on the slide, which is a person engaged in an activity which involves spending time unpaid. I stress unpaid because we're going to talk about that in a minute, except for travel and other out-of-pocket expenses, doing something which aims to benefit some third party. Now, that isn't particularly helpful because as a lawyer and as a potential person who engages volunteers, we need to know what the legal status, if any, a volunteer has. Now, the legal status of an individual is very important as it determines the extent of any statutory employment rights that they have against the organisation which they're providing services for. The legal status of volunteers isn't clear-cut, unfortunately, as there's a vast range of different types of relationships, from the purely voluntary, as it were, to those who are clearly contractual and everything in between. Those are the ones that are difficult to define, and those are the ones that come with inherent risk. This ambiguity makes it very difficult for organisations taking on volunteers to appreciate any legal obligations that they may actually owe them. What we're going to look at now is some cases, because I think, without wishing to be too lawyery about this, it really is very useful to look at a couple of actual cases that dealt with volunteers and how they were dealt with by the tribunals, because I think it puts into kind of quite stark reality a situation which organisations encounter every day. So let's have a look at this one. It's Mrs. Chowdhury. She did administrative work for the Migrant Advisory Service for 2 years, and she claimed unfair dismissal and sex discrimination when her role was terminated. So the kind of things that you'd expect an employee to claim. She worked 4 mornings a week and was paid volunteers' expenses of £25, which increased to £40 a week, even though she incurred no expenses. Seemingly, she didn't receive them. She was also paid the same expenses when she was on holiday or sick. Now, the Employment Appeal Tribunal, which is the highest employment tribunal, an upheld the tribunal's decision that Mrs. Chowdhury was actually an employee and therefore entitled to pursue a claim for unfair dismissal and discrimination. Now that's a little bit frightening, I think, but I think it shows very, very clearly the lesson here of being too nice does enhance risk on some occasions. So obviously the Migrant Advisory Service thought they were being jolly nice to Mrs. Chowdhury by paying her the volunteer expenses, because she probably did get the train or the bus there and she probably did incur some expenses. But unfortunately the mistake that they made was not getting receipts for the expenses and paying those expenses consistently, especially when she was on holiday or sick. So it essentially looked like wages. Another example of a case, Mr. Murray, he claimed disability discrimination against Newham Citizens Advice Bureau. The Employment Appeal Tribunal in this case held that the volunteer agreement, we'll talk about volunteer agreements in a little while, in which Mr. Murray agreed to volunteer at specific times and for a minimum period, and the CAB agreed to repay his expenses and provide him with basic training, that actually amounted to a binding contract. Mr. Murray was found to have been employed under a contract of employment, and yes, he was entitled to pursue his claims. I think the lesson here is that even if the organisation attempts clarity in the form of a volunteer agreement, the tribunal will always look behind that at the reality of the situation. And I think that's a theme that runs through this whole webinar, that even if you want something, an arrangement to be something, unless it actually is in reality, the tribunal will not accept what it is supposed to be on paper. So volunteer agreements, very briefly, and we'll talk about them later, are akin to a contract of employment, but they basically are between the volunteer and the organisation. They set out exactly what it is that the volunteer is allowed to do, is expected to do. It is not supposed to be a contract of employment, so they need to be drafted very, very carefully if they are put into place. You'll see how, in this case, Mr. Murray, it went very wrong for the Citizens Advice Bureau, and therefore if organisations are wanting to enter into volunteer agreements, they can be an excellent idea and provide boundaries for volunteers and clarity, but certainly they can go wrong. Okay, so let's have a look at some practical tips for reducing the risk of actually getting a legally binding employment contract when what you've set out for is actually a volunteer arrangement. So here are some suggestions, and they're derived from the case law to reduce the risk of organisations creating a legally binding contract with volunteers in the form of an employment contract. It may not be necessarily realistic to avoid all the potential risk factors, but removing some of the indicators of a contractual relationship should be possible, really. So avoid making payments to volunteers that look like wages. Mrs. Jowdy, obviously classic example. Obviously, payment to cover actual expenses should be clearly identified as such and ideally reimbursed against receipts. Remove or at least minimise perks that could be seen as consideration indicating a contract. Go right back to first principles, my first day at law school. What makes the contract? A contract is offer, acceptance and consideration. And in the employment law world, obviously in an employment contract, the consideration is obviously your salary or remuneration. It can be other things though, it can be perks, it can be benefits. Now obviously if you've got a volunteer who's been given perks or benefits, then that indicates that there's some consideration and therefore a contract. So try and reduce those kind of perks. Reduce obligations on the part of the volunteer. Give the volunteer ability to refuse tasks and choose when they want to work, and that will point away from the existence of a binding contract. And adopt flexible language such as usual and suggested. Avoid using language that makes the arrangement sound contractual. And of course, we all want to do this, treat the volunteers fairly. Have clear procedures for dealing with problems and grievances. Should reduce the likelihood of disputes with volunteers. They do happen, unfortunately, especially when organisations rely quite heavily on volunteers. And we talked about it a little bit. Consider using a volunteer agreement. If you are going to, you can find some wonderful things online. If you want to have a look online, you can also get the advice of legal advice of people like me to draft a very simple but clear volunteer agreement. I think another one of the themes running through this is if you are going to put documentation in place at this stage in your organisation, it needs to be brief and it needs to be clear. There is no point for your organisations having reams and reams of staff handbooks and contracts. That just won't work. It may work for a PLC, but not at this stage for your organisation. So if you are going to use a volunteer agreement, it needs to be very clear and very brief. You also need to think about what policies will apply to volunteers. So if you have employees and you already have a staff handbook and you have grievance procedures and disciplinary procedures, then you need to consider whether they will apply to volunteers. If you're not at that stage and you're really just relying on volunteers, what about putting those procedures in place for volunteers? And then when you obviously then go on to take on employees, you'll have them in place. There's nothing wrong with doing that, and it certainly doesn't indicate that those individuals are actually employees. What it indicates is that you want to treat them fairly, and that's a positive thing. I'm going to talk a little bit about the national minimum wage, and you may think well, why does that apply to volunteers? Surely that's not the point. Well, unfortunately, the legislation governing the national minimum wage requirements dictate that employers must pay the national minimum wage to all workers. You appreciate I didn't say employees. A worker is defined very differently to an employee, and a worker is defined as an individual who has entered into or works under either of the following, either a contract of employment as your employee or any other contract, whether express or implied, whether orally or in writing, whereby the individual undertakes to do or perform personally any work or services. Pause there a little bit. You can see how very easily that definition could catch some volunteers. It's easy to see, therefore, that you could get into some difficulties in relation to the national minimum wage in relation to volunteers who are perhaps not volunteers but are workers. The current rate of the national minimum wage is £6.50 for an adult, and there's obviously other rates for £3.79 for under 18s. And the consequences for an organisation of failing to pay the national minimum wage to volunteers who are in fact workers and therefore entitled to the national minimum wage are potentially quite serious. Not only could the organisation be required to pay up to 6 years of backdated national minimum wage, don't all scream at once, but it may be liable for actually a criminal penalty if it's willfully neglected to pay the national minimum wage. Now I think a small organisation who really just did not know that volunteers, I don't think would be caught by that criminal penalty, but equally it's easy to see how you may be caught in relation to a disgruntled volunteer who considers themselves to be a worker. What I would say, the government has issued some guidance on the national minimum wage, and it's on the gov.uk website. It basically sets out the basics of who and who isn't entitled to it, sets out some useful advice on who it considers is and isn't entitled to the national minimum wage, and it is worth looking at. What I would say is there is an exemption called a voluntary worker exemption. Now, voluntary workers are a category of worker who work for charities, voluntary organisations and associated fundraising bodies who are not entitled to the minimum wage if the following conditions are met. So they receive no monetary payment other than the reimbursement of expenses, and they receive no benefit in kind. So there is the get out, but only for very specific charitable organisations. Now, obviously, if you've got a volunteer who's tipped over into being a worker, they get other rights. They get a right to holidays, statutory holidays, which are currently, for a full-time employee, 28 days and include the 8 bank holidays. They also get other statutory entitlements, such as rest breaks and things in relation to working time. We also are slightly caught by the Equality Act, not in relation to employment-related discrimination, but in relation to the provision of goods and services. It's easy to see a circumstance where offering opportunities for volunteering, an organisation is providing a service, and consequently the individual volunteer is protected in relation to the Equality Act. A bit of a right at the traffic lights type of argument, but you'll appreciate the point that if your volunteers tip over into being workers, they do get an awful lot of rights. Okay, let's have a look at self-employed workers or freelancers. Now, this might seem the natural step forward for engaging volunteers to carry out all the work. However, as with the volunteers, if the relationship is not absolutely clear and certain, the organisation can expose itself to a significant amount of risk. Now, obviously, the main risk is that the individual concerned will actually be found to be an employee. And obviously, in order to establish how to avoid this situation, we need to look at what employee status actually is and what the triggers are. Okay. The definition of employee is an individual who's entered into or works under a contract of employment. A contract of employment means a contract of service or apprenticeship, whether express or implied, and if it is express, whether orally or in writing. Pretty self-explanatory, eh? Well, no, not really. You would think so. But no, the concept of a contract of employment is one that's been explored extensively in case law and has been and continues to be and continues to keep a lot of people in jobs, very much like me. It is always, going back to this point I made at the outset, it is always a matter of fact and not what the parties actually intend or even want. The significance of the distinction. The distinction between being self-employed or an employee is significant for a number of different reasons, including the following. Employers must provide employees with a bare minimum contract. It's often called a Section 1 statement, and we'll talk about what needs to go in a Section 1 statement when we come on to actually engaging employees in a minute. And that must contain certain contractual promises, pay, holidays, etc. Employers and employees have obligations that are implied into the contract between them, which obviously a self-employed person wouldn't have. For example, the mutual trust of duty and confidence, confidentiality, things like that. And there are some core legal protections that only apply to employees, which I'm sure we all know about. They're most particularly the rights on termination of employment, i.e. the right not to be unfairly dismissed and the right to receive a statutory redundancy payment. And only employees are covered by the ACAS Code of Practice on Disciplinary and Grievance Procedures, which if you become an employer, you will become very familiar with. That requires you to do certain things in relation to disciplinary and grievance. We'll talk a little bit about how it comes into play in relation to termination in due course. A couple of things at the end as well. An employer is required to take out employer's liability insurance to cover the risk of employees injuring themselves at work. Self-employed individuals or independent contractors may not in every case be covered by this, and they may ought to consider getting their own. An employer's own employee statutory duties relating to health and safety, and independent contractors may not be covered under these duties. So there's quite a lot of significance in the difference. I think the main one has to be the core legal protections in relation to unfair dismissal. So over the years, several different tests, I'll stick them all up on the slide at once, have been used to identify whether an employment relationship exists. So if you're engaging somebody on what you want to be in a self-employed contractor or a freelancer, it is worth running through these tests to establish whether actually you're engaging an employee in reality. So effectively, it now seems reasonably settled in law, although things are never really settled in law, that whether there is a contract of service, i.e. the person is an employee, falls to be determined by consideration of a number of factors, the multiple test, as it's called, as opposed to one single test. So one of the key legal cases determined that the key tests for the existence of an employment relationship were that an agreement exists to provide the individual's own work or skill in the performance of service for the organisation. That's personal service, in return for wage or remuneration. There is a control of the individual by the organisation, and that the other provisions are consistent with a contract of service, what's called other factors. So personal service, just very briefly, it's a situation where an employee would, other than in very extremely limited and exceptional circumstances, be required to provide personal service. Whereas in the case of a self-employed or independent contractor, they should be able to provide a substitute or subcontract the service obligations. Now, I don't think that often gets thought about when people are engaging self-employed contractors. Would you be happy if that person was ill for them to appoint a suitable substitute? Obviously, there must be wage or remuneration, otherwise there will be no consideration, going back to that contract point we talked about earlier. Mutuality of obligation is the obligation on the employer to provide work and the obligation on the individual to accept that work. Pretty straightforward. Now, control is where things often go a bit wrong in relation to self-employed individuals, and that's where it tips over into them being employees. So control includes the power of deciding the thing to be done, the way in which it's done, the means by which you do it, the time that you do it in, and the place where it's done. All those factors need to be considered together to determine whether one party has control to a sufficient degree for them to be, in rather old-fashioned language, master and the other servant. We still use that terminology because it's quite easy to demonstrate that one person is actually controlling the other. If that is the case, then that is classically an employment relationship and not a self-employed type of relationship. So an employee would commonly be told their place of work, their working days, their hours. They'd be subject to the employer's day-to-day direction, rules, policies, standards of work, etc. A self-employed individual would usually, and you'd expect to see a greater degree of freedom in their method of working. For example, they would probably work more independently from the employer, be less likely to be submitted to the same controls or supervision, and they determine their own working days and hours. The other factors we talked about, which is kind of random, well, we've got these three wonderful things, and then we're going to, let's put in other factors. There appears to be a general consensus among judges that control and the other factors we've discussed are not sufficient to determine the question of employment status. Other factors do need to be considered, and it's necessary to look at all elements of the contract to determine its nature. So other relevant factors might be who provides and maintains the equipment that are used, whether the person hires their own help, the degree of financial risk adopted by the individual, and the degree of investment in and management of the business or the organisation concerned, whether the individual has an opportunity to profit from their own performance, and whether the person is paid a fixed wage or salary. Also absolutely key, and where a lot of people fall down, is that they pay individuals when they're absent due to holiday or sickness, and that is a classic indication of employee as opposed to self-employed contractor. So we've had a look at the differences between employee and self-employed individuals. Let's have a look at your statutory duties in relation to what must go in a contract of employment. So employers are obliged to provide employees whose employment is to continue for more than 1 month with a written statement of certain terms of their employment. That's what's called required statutory particulars. It's often referred to as the Section 1 statement. It's just a reference to the legislation. It must be given to employees no later than 2 months after their employment begins. And they can be given at different times, but as long as they're all given by the end of the 2 month period. So usually the Section 1 statement, as we call it, is given either in the form of a letter of engagement or a contract itself. And in the form of those two things, it's either given before or after the employment starts. It can be given in more than one document, so it can be given in the letter and the contract, as long as you make sure that you give it all within 2 months is the key. So those are all the things that need to go in there. I won't labour the point, but a couple of them need a bit more explanation. So names of employer and employee. And stating the obvious, make sure the name is correct, not of the individual employee, but of your organisation. If your organisation is a charity, you need to make sure that it's the charity name as registered with the Charity Commission. If it's a business, obviously Companies House, and it's worthwhile putting the charity number and the company number depending on the status of the organisation. It's quite often people do slip up in relation to that, and there's lack of clarity as to who actually employs the individual, what the nature of the actual organisation is. So the date the employment starts and the date the periods of continuous employment began. The reason I say continuous employment, because some of you may be aware that if people, what's called TUPE, transfer in from another organisation, their start date, as it were, or their continuous employment date may be before they actually started employment with you. But that's a bit of a discrete point which is outside of this seminar, and you could do a whole seminar on that, but that's what you need to put in. Obviously pay, or method of calculating it, and the interval of payment. What day every month the individual, if it's a monthly payment, will it be expected to be paid? So if it's the last day of the month, put the last day. The hours of work, holiday entitlement and holiday pay. As I said before, the minimum statutory for a full-time employee is 28 days, and that includes the bank holiday. The employee's job title or a brief description of the work. I would not encourage people to append job descriptions to the back of contracts for employment. The reason being is if either you or the employee want to amend that job description in due course, then you're talking about a contractual change which is quite difficult to actually affect. It needs the employee's consent. And also it just gets very tricky when you're arguing with an individual, a difficult employee, and I hope you don't have them, but unfortunately we do get them, where they point to bits of their job description and say, well, this isn't in my job description, I'm not doing this. And if that job description is appended to the back of a contract, that makes it contractual and very, very difficult. So please don't do that. Just a very brief description. So my contract will say that I am a solicitor. A teacher's contract will say that they are a teacher. My contract does not say I work within the employment department and I specify in the not-for-profit sector. Probably my job description would now do so, but it is not appended to the back of the contract. Okay, place of work. It is possible to put a number of places of work. It's also possible to give yourself a little bit of flexibility in what's called a mobility clause. So we would put, you are required, your main place of work is X, but you may be required to work in other places within a reasonable distance from time to time. Something along that line is quite useful in some respects. Okay, terms relating to absence due to incapacity and sickness. There's no requirement on you to pay sick pay in excess of the statutory sick pay, which is after 4 days. It's not my particular area or specialism, statutory sick pay. I think it's after 4 days now. I think actually the law's just changed that you can't reclaim SSP, statutory sick pay, anymore. There's no obligation on you to make any payments in relation to contractual sick pay. Of course you can do so if you want to. And a notice period for either party. There is a statutory minimum notice period, and that is 1 week for each complete year up to 12 weeks. Many people obviously give in excess of the statutory notice period. Many people do the kind of month on either side, but then they don't take into consideration length of service. So when that individual gets beyond 4 or 5 weeks service, 4 or 5 years service, their notice will actually increase in line with the statutory, because it's always the statutory, which is 1 week for each complete year, up to 12 weeks, which prevails. Okay, information about the disciplinary and grievance procedures. So although the law doesn't say as an employer you have to have a disciplinary and grievance procedure, the employment contract, the Section 1 statement, says that you have to make reference to certain parts of it. So it says that you have to tell an individual where they address a grievance and who deals with appeals of disciplinary, rather oddly and randomly. So really, you need to have a very basic disciplinary and grievance procedure in place if you're going to start employing anyone. Now, again, going back to simplicity and clarity, there is no need for a very small organisation employing their first handful of employees to have War and Peace as their disciplinary and grievance procedures. You can have a disciplinary and grievance procedure probably on a couple of A4 sides, and that's what I would encourage. Very simple, in accordance with the ACAS code, which we'll talk about in a minute, and very basic. Pension entitlements. The only reason I put this in is because it's required by the Section 1 statement, and obviously I used to be a pension lawyer for a while, so I unfortunately get excited about pensions rather sadly. You do need to put something in there about pension entitlement. You also need to put in a statement about whether you have a contracting out certificate. No one would know what this means, apart from probably a few pensions lawyers and a couple of employment lawyers. There's people sat next to me in my office who are solicitors who are in the employment department who don't know what it means. So don't worry about it, but you do need to put it in 99.999% of the time. You will. Could everybody, Monica, I'm getting a message saying that there's a sound problem. No? Okay. Okay, I'll carry on. So you need, in 99% of the time, you will say that a counter-contracting out certificate is in force. You also need to comply with your auto-enrolment requirements, which is very, very basically, if you've got individuals who earn more than £10,000 a year, and they are on a contract of over about 3 months, you need to have a pension scheme available to them, and you need to contribute. At the moment, it's 1%. Each employer is given a staging date. You need to check on the pensions regulator website in relation to when your staging date is. But for very, very small employers, as you will be, it won't probably be until about 2017, but it is something that you need to factor in, especially into your contracts of employment. You need to include a very basic thing in relation to work outside the UK. If you do require people to work outside the UK, you need to say so, and conversely say that you will not expect that. Terms in relation to length of the contract, and if there's any collective agreements which comply, which is usually things like whether you recognise a trade union, which you probably won't. Okay, there are consequences for not providing a Section 1 statement, which is a tribunal award of between 2 to 4 weeks' pay. The individual needs to bring in another substantive claim, but there is a penalty for not doing that. So it is obviously worth doing for good employee relations, but equally it is worth doing in relation to the potential sanction. Okay, we're going to whiz through it because I'm conscious of the time. We're going to whiz through. I thought it might be useful if I actually just do a few slides on termination, because I think a lot of people are a little bit kind of frightened by thinking, oh, I might have to terminate somebody's contract. What do I do? Now, as I say, I'm going to whiz through it a little bit and allow time for questions, but I think it's absolutely key that you understand the basics if you are going to engage somebody, equally the basics of how you go about extracting yourself from that kind of situation. Now, I've left this point on the screen because 2 years is the key date. It used to be the case that you had to have 1 year's service to claim unfair dismissal as an employee who was arguably unfairly dismissed. The government increased that a couple of years ago now to 2 years. So unless the individual that you want to part company with has 2 years service, 2 complete years service with you, it means that you are not at risk in relation to unfair dismissal. I'm talking in general terms, there are exceptions. But that doesn't mean, obviously, that you can treat employees with less than 2 years service unfairly, and there are certain risks associated with it. But the risk is massively reduced if they've got 2 years service. Okay, so if you've got over 2 years, the dismissal of an employee for a reason other than one allowed by law without following a fair procedure can lead to a claim for unfair dismissal, and that's what we're talking about. Obviously, dismissal without the required period of notice can lead to a wrongful dismissal claim or a breach of contract claim, and if the dismissal is for a discriminatory reason, there will also be a discrimination claim. But let's assume that we're not all going around breaching contracts and discriminating against people, because one assumes that we're not. The main issue that we're worried about is effectively unfair dismissal. Now, people get quite concerned about it, but I think it is worth putting it in context. Obviously, people bring employment tribunal claims for unfair dismissal. The average unfair dismissal award, although you see all these random things on the news about people getting $250,000, all kinds of exciting things like that, the average unfair dismissal award, I think, in 2011-2012 was £4,500. Now, that's not an awful lot. However, regardless of whether that claim succeeds, the management time and legal costs spent in defending a claim of unfair dismissal are far outweigh any potential compensation that the individual might be awarded. So I think, in short, it's worth avoiding. So how can you dismiss somebody lawfully if they've got over 2 years' service? Say the 3 fairs. So you've got to have a fair reason, follow a fair procedure, and act fairly and reasonably. Got to comply with their contracts, so give them notice, and obviously not discriminate against them. What I should have put on there is get some legal advice as well. I mean, to be fair to the vast amount of stuff on the internet, I mean, you know, ACAS website is fantastic, the Citizens Advice Bureau equally fantastic, and you know, Google is wonderful in relation to just finding out the very basics. But if you've got a very specific scenario, you really need to get specific advice. Okay, so we talked about a fair reason for the dismissal. There are 5 fair reasons. This has changed since the time I've been in practice. I used to have 7, then I went to 6, and then I went down again. But now currently there's 5. Conduct, capability includes ill health, redundancy, illegality, which is things like the person hasn't got the right to work in the UK because of their immigration status. And the last one is some other substantial reason. Now that's the catch-all category of potentially fair reasons that don't fall under the other categories. So that category can include things like failure to agree changes to terms and conditions, pressure from third parties, things like something that's fallen short of a redundancy or a breakdown in trust and confidence between the parties. I think it'd be dangerous to, and I always tell clients, it's dangerous to rely on SOSR as the kind of, oh, I can't think of anything else, so let's stick it in SOSR. You really should try and shoehorn any kind of dismissal into the 4 above. So effectively, a dismissal for any other reason apart from those will be unfair. Put a question mark about retirement. Before April 2011, retirement was included, so we used to have 6 fair reasons. Now, any dismissal based on age would be unfair. You'd have to, we do get some dismissals that have to be based on, are based on age, but you have to be very, very careful and certainly get very, very detailed advice on that. There are certain dismissals, or certain reasons for dismissal, which are automatically unfair. They include dismissals for a reason connected with pregnancy or childbirth or whistleblowing, etc., etc. But I'm sure we're all not going about sacking pregnant people left, right and centre, so let's not worry too much about that one. Okay, so you must follow a fair procedure. So even if you've got a fair, potentially fair reason on the last slide, you must still follow a fair procedure before deciding whether to dismiss. Now, ACAS code is absolutely cracking. Have a look at the ACAS code. Even if you don't do anything else, you have to look at the ACAS code. And to be honest, if it goes to tribunal and the tribunal thinks that you haven't put the ACAS code, they may bump up the compensation that they award by up to 25% because you haven't, which is not very pleasant really. So there's no real reason for you not to look at that. And another reasonable, the last reasonableness that we've got here, your dismissal has to be within the band of reasonable responses of a reasonable employer. Well, what does that mean? I think you need to stand back and have a think about it, get some external advice, but it is effectively the kind of catch-all for disproportionate dismissals fall foul in relation to the band of reasonable responses. So somebody's done something that you and I would probably think would be a final written warning. It's pretty serious, but somebody dismisses, that may be fall outside the band of reasonable responses. Saying again, you need to dismiss in accordance with the notice period. You need to be conscious about discrimination. You also need to provide written reasons. if the individual has got over 2 years service who is within the unfair dismissal, you do need to provide written reasons within 14 days of them requesting that. You should do that anyway. I mean, it is good employee relations to do that. So whiz through some common pitfalls, and I think we've probably covered most of these anyway. Volunteer being too nice and expenses become wages. The intention is that people will become self-employed, but they get too much control and they've been there too long. And the long service indicates that they're actually found to be an employee when you want to terminate them. You want to terminate because you, the individual is unsuitable, but not knowing how. Well, 2 years is the absolute key to that, so you need to think about your 2 years. And carrying out a fair dismissal, we find it all the time. People ask, how do I carry out a fair dismissal? Refer back to ACAS again. ACAS is your go-to place. This is an interesting one. Paying for holiday instead of making sure an employee takes it. You really should ensure that employees take holiday. You can't really, the government and the employment tribunals do not like it when you pay individuals instead of actually making sure they take holiday. It happens a lot in the hospitality industry, but not so much in normal life, as it were. And going back to this, putting too much in the contract or a lack of clarity, please do, put the bare minimum in the contract in compliance with Section 1. But clarity is absolutely important. And overcomplicating disciplinary grievance procedures or not having procedures at all is a common pitfall. Those are my details. I think we're just about done in relation to the actual presentation. Enrico, if you want to, I'm happy to take questions.
That's great. Thank you so much, Jean. Really, really useful. And yes, I have questions, and no doubt people now that we've come to the end, people probably will have more. So please type them in, and we will go through as many as we can. But I suspect we may not be able to go through quite all. But let's start with the ones that I have, and it's somebody's quite a specific scenario, but actually I think quite a common one for a number of social entrepreneurs we work with. So this entrepreneur, they have a cafe. It's a pop-up cafe. Things are going well and they are growing. At the moment, they have 2 members of staff that they pay, but they are not sort of contracted employees. They are more like freelancers, so they invoice the pop-up cafe for the work they do. Now, the entrepreneur, he'd like to put them on a payroll and actually have them as employees if possible, but not quite sure whether to do that and how to proceed, because it's still quite early days and there is no real job security at this stage. So just kind of at that stage of what to do and what would be the right thing to do in this circumstance.
Yeah, I mean, I think probably in these circumstances, sorry, I just wish you could mute yourself because I can hear myself, but thank you very much. Rather off-putting when you can hear yourself back at yourself. I think in these circumstances, those individuals really have tested, and I don't obviously know the details of the circumstances, may be actually employees anyway. So I think, I mean, my view would be, I think you should bite the bullet and you offer them employment contracts. Going back to this kind of 2 years is key. Then the lack of job security. I think every entrepreneur and every new business needs to keep an eye, if they are engaging individuals in employment contracts, needs to be aware of when those people that they've engaged are coming up to 2 years, because it's awful if you then get to a situation where you've got individuals who've been employed for 2 years and 1 month, and then suddenly you lose a funding stream or whatever, and then then you have to make them redundant. If you can see that coming, oh right, I've got the 2 individuals, but things aren't looking great. Okay, well I'll terminate. That's a much better situation than going over the 2 years. My view would be to bite the bullet and actually sit down with both individuals and say, look, you're currently on self-employed contracts. My preference would be to get you as employees. They may even have a different view. They may say, well, actually, no, I prefer to be self-employed. See how that conversation goes, but I think it would just provide a lot more clarity and therefore less risk if you got them onto employment contracts, very simple ones at that.
Okay, thank you for that. So would, in terms of next steps for the entrepreneur, would they need to consult an employment lawyer to get the contracts and next steps right, or is it relatively simple? Are there sort of template contracts that they could use to do this on their own, or would you recommend using a lawyer?
Yeah. You can get template contracts online, but some of them are not great, and you don't know when they've last been updated. I would never, want to push entrepreneurs into, using the services of a lawyer when they don't need to, but getting a very standard basic contract, which you can then use again for future employees from a lawyer, is, I think, probably a very good idea in these circumstances. A very bit of brief guidance as to how you go about, it's basic employee relations, sitting down with them and just saying, look, this is what I want to do, how do you feel about it?
Okay, thank you. And I know UnLtd also has some employment contract templates that we can share with people if they need to. So as a starting point. Okay, so hopefully that helps. I know the cases, obviously there's probably a lot more questions just by answering that to go through, but we'll leave that particular case at that. Now, the second question, a little bit different. How can you avoid a volunteer tipping over into becoming a worker for national minimum wage?
Okay, well, I think the key is in relation to actual expenses, in my view. Well, two keys. Expenses and the expectation that that individual will turn up. Now, I know it's very, very difficult because you want to have an expectation that a volunteer will pitch up, because you'll be in difficulty if they don't. But that's the absolute key with volunteers, that it's not an obligation. I gave some advice to a religious charity where it was to do with people coming in and cleaning, and they were saying they have a rota, and is that a bad idea? Does that indicate worker? Well, I think, a volunteer rota is not a bad idea, and I don't think it necessarily indicates obligation, but it's edging towards that, isn't it? And I think it is very difficult, but I think if you're absolutely militant in relation to your reimbursement of receipted expenses, if you have a volunteer agreement in place which is absolutely clear and you stick to that volunteer agreement, let's forget the case of Mr. Murray because it was a bit of a scary one, and you make sure that there's, that you try and keep obligation to a minimum, then I think you're in the safest possible place. There is no hard and fast rule in relation to, if you do this, they will not be a worker. It is difficult. I think what you can rely on as well is that volunteers are generally all very, very nice people, and things only go wrong every now and again. The reason that there aren't that many volunteer cases is because of that, and I think you rely on goodwill for them to do what it is that they're doing for you, and you also rely on goodwill that they won't actually go off to an employment tribunal and claim that they're entitled to 6 years' worth of national minimum wage. So there's no hard and fast rules, but I think expectation and the expenses are absolutely key.
Great, thank you. Hopefully that answered the question. Another one. So our organisation works in schools and therefore only during term time. We are looking to take on people to deliver some of our sessions. Would the fact that they are only working during term time and therefore regularly have breaks in their work mean that the employee structure you have described applies? Also, if they only deliver a day or two a week, would they still be classed as employees?
Short answer is absolutely yes. I work constantly with schools. I draft term time contracts. Your employment with that organisation works as an umbrella over any gaps. In fact, Stone King engage people on a term time basis because we work so predominantly with schools, so we go very quiet in the summer because all the schools are away. But it doesn't mean to say that those individuals aren't still employed by Stone King. The employment relationship is suited to term time contracts and can be adapted, and as long as you write the provisions in the contract which are necessary, absolutely yes. Short answer.
Great, thank you, Jean. Another one. This is in the context of a training agency. For training agencies, the freelance trainer model requires an organisation to dictate place, time and training content, and often involves the organisation providing materials and content and even training in how to deliver that content. how can this still fall in the self-employment world if it's in a grey area? Not sure if that, does that make sense? I'm not sure if that question makes sense to me. How can this still fall in the self-employment world if it's a grey area?
Slightly, I think it is. I think the fact that this is a training agency, there are very specific provisions in it, because you are talking about agencies here. You're providing individuals for service to another organisation. I think I probably need a bit more information about that in order to answer more fully, then I think the answer might be quite specific to that organisation. If we're able to get an email address or get some further detail about that, Rika, that would be helpful.
Okay, thank you. I'll make a note of the person's name, but if they are also still online, which I think they are, if perhaps you can note Jean's email from the webinar and drop her a line directly. Yes, you can contact Jean directly. He's just asking. Great, thank you. Okay, question about interns. What is the legal status of interns? I'm not sure if you've got any information on that, Jean, because I know there's been a lot of debate around interns and whether they are paid and all of that.
I did a seminar a couple of weeks ago about interns, actually, and the difference between interns and volunteers. Interns are in the same category as in relation to volunteers, in as much as there is no statutory definition of interns. It is something that has evolved over time. A lot of charities are using interns because they realise, especially with reasonably high youth unemployment, that, and it's usually younger people that become interns, that they're realising that there's an actual wealth of talent out there which can work in both ways, assist the individual with their CV and also assist with the organisation with some quite highly skilled work. There isn't any statutory definition. Legally, they really adopt the same kind of category as volunteers, so you still need to have the same concerns in relation to workers as you have in relation to interns. So I know that quite often interns are paid for a period of time, which is difficult in relation to, entitlement to holiday, entitlement to statutory entitlements, etc., working time things. But unfortunately, without wishing to sound too much like a lawyer, it depends on the actual circumstances concerned, and it's also a very grey area. The reason it hasn't really come to the fore is because people are more than happy to be paid whatever it is that the investment bank usually pays them historically in relation to that internship, and they're not going to complain about it. But really, when we talk legally about interns, they're exactly the same as volunteers and have the same risks inherent in them.
Great, thank you, Jean. At least one more question. There's a few more on the list, but let's ask at least one more. Could you say a little bit more about the capability in terms of the member of staff who has